immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello, everyone, and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates, and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. I'm your host, GB Satusa, and we are discussing cancellation of removal for non-permanent residents, eligibility strategy, and real case scenarios. Now, today, many individuals facing removal proceedings are often unaware that certain forms of relief may be available to them. One such form of relief is cancellation of removal for non-permanent residents, which can offer a path to remain in the United States under specific legal conditions. However, the process is complex, highly discretionary, and requires a thorough understanding of eligibility requirements and supporting evidence. Now, for many individuals and families, understanding how this form of relief works is most helpful. Preparation, proper documentation, and strategic case presentation play a significant role in the outcome of the case. Now, to help us break things down, we are honored to be joined by attorney Natalie Driver Womack, an experienced immigration attorney with a focus on removal defense and complex immigration matters. She has worked extensively with individuals in immigration court, guiding clients through high-stakes proceedings and helping them navigate the legal standards required for relief, such as cancellation of removal. Attorney Womack, thank you so much for joining us today. We're thrilled to have you for this important discussion.
Thank you for having me. I'm happy to be here.
Now, before we begin, a quick reminder to our audience, immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us from Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding this important discussion. Now, let's dive right in. Attorney Womack, can you explain what cancellation of removal for non-permanent residents is, and what situations this form of relief is available?
Sure, no problem. So I think it was great, your introduction, because it highlighted exactly what it is. So you would have to be, unfortunately, in immigration court. But once you're in immigration court, it does not mean the end of the world. There's viable options. And this is one viable option, which is the 42B, and that is the cancellation of removal. And what this does is says, please stop, cancel my removal from the country because I have been present in the US, and you have to have a certain amount of time. I have good moral character, and that if I were to be removed, I would be harming my US family.
All right. Now, what are the eligibility requirements?
Okay, so there are four major requirements. For the first one, you have to show continuous presence in the US for 10 years. So that is a long time, but it's a very important aspect. The second one is that you have to have good moral character. So you have to show that you are a good person. Now, the second one and the third one, they somewhat overlap to some degree. And the third one is that you cannot have any criminal convictions. Now, when I say any criminal convictions, you can have some, but there will be certain ones statutorily that will eliminate you from eligibility. And then the fourth one is to show that there's hardship to your US family or your lawful permanent resident family if you were to leave.
Now, what types of evidence are most effective in demonstrating hardships to a US citizen or lawful permanent resident relative?
Yeah, so this is where it's important to make sure that you're connecting with an immigration specialist, right? You want attorneys who specialize in this because your first thought is, oh, I can put this information together. But you putting it together versus a third eye with that legal, that eagle eye, it's different. Okay. So you want to make sure that you have medical records. All right. But those medical records have to be sound. Okay. You want to make sure those medical records are documenting something that is one, going on currently. Two, it's from an actual doctor who is stating what your issue is, what the prognosis is, and what your treatment in the future looks like. Okay, so one aspect I have seen individuals do when sending some of their reports, they may send you 2 or 3 of the pages because they're like, oh, pages 1 and 4 don't matter. Again, that's one of the reasons why it's important to be with a professional, right? Because at that point, if the court gets 2 of the 4 pages, we're going to have an incomplete document. Okay. So you want sound medical evidence. Okay. Then another one is evals for potentially psychological evals. If it's something that is emotional or something that is going on with your family members, if you were to be removed. Now, again, this is not about the individual who's applying. It's about your family, how these matters affect your family's medical issues, not yours. Okay. So again, you want to make sure your psych evals that they are sound, that you're also getting them from the correct professionals. In taking on this work, I realized that there are individuals who will say that they're doing a psychological evaluation. They will say that they're doing an evaluation, but I'm very intent on seeing how that evaluation comes together. What are you bringing to the table? Because you can open up certain things that you should not open up in those evals. So that evaluation, it must be tight. Affidavits from individuals to state the veracity of what you are saying. Now, I don't tell anyone what to say in their affidavits, but I vet the affidavits, I vet the psychological evals. Your attorneys will do that because there can't be something in your documentation that raises a red flag to something else, right? It has to be all legally making the argument that this displacement would be a harm to your family. So your evidence must be sound. It may also be the fact that you have to provide financial information to show that there may be a loss of income from your family because the job that you have or your family member has is not available in the country if you were removed. So these are all the major aspects, and you have to make sure that that evidence is sound and tight.
Yeah. Now, can you walk us through how a typical cancellation of removal case proceeds in immigration court, from application to final decision?
Sure. Okay, so the first thing that happens is the scary part, and I know individuals that is the part where you're not, that's where emotions are invoked. You will get what is called an NTA, which is a notice to appear. And I've had a lot of people on the other side of the phone telling me that they have a notice to appear. And I understand, I haven't been in the situation, but I sympathize and I truly get the concern and the worry. But if you have someone who's on your team and they're assessing all the various aspects of what could happen, is that they're actually saying, okay, so now that we have the notice to appear, this just tells us that we have to appear before the judge. Okay. And with that notice to appear, you'll come before the judge. The judge will make sure that you, as well as DHS, you're clear on what is being charged and what is being alleged. If there's anything that you want to bring up then, your attorney will bring it up then. But that is your notice to appear, and that is your master calendar hearing. That's the first hearing that you have. And that is just situational awareness that we believe that you're in this country illegally. Here's the reason why. Here's what we're charging you with. Then at this point, that is when you state, here's the judge, we have a prayer for relief. Our prayer for relief is that we'd like to file for cancellation of removal. So at this point, the judge will then allow time to file your form, okay? Your form and your supplemental evidence, and then set out another date, which would be your merits hearing. And that merits hearing is where substantively information is and your case happens at this point. Now, at this point, the judge will either grant or deny your application, okay? If you're granted, Wonderful. Now you're on the road. You're becoming a lawful permanent resident. This is a wonderful aspect, success. Okay. But there are instances when you are denied. And if you are denied, again, denial, it just may mean just simply delay. Okay. So at that point, you do have another option of appealing to the Board of Immigration Appeals, also known as BIA. So that's kind of like the flow process. Now, it takes time. This is not something that happens very quickly. It will be time, it will be stressful, but you just have to work through.
Now, attorney, are there common mistakes or weaknesses in applications that tend to lead to denials?
Yeah, so what I think that is the main aspect of denials when, like, even looking at paperwork that has been filed for other claims, if you're coming in on the attorney as like the second leg, it will be the fact that the evidence is not sound, it's not tight. Okay. And when I say tight, I mean, if I'm looking at this documentation, then I'm showing the judge to prove a thing. I need to look at it for what I think it says, as well as what I think the judge may question. So if I think that there's something that the judge may question, I preemptively strike and I add new evidence on top of what I'm submitting. Okay. So one of the aspects of individuals when they're submitting, when I hear that there is not success, is they'll say, well, I do think that my kids would suffer from simply, me being removed and it would be problems. Okay. Saying it and documenting it is different. It's a different aspect. Some individuals have claimed this without that supplemental evidence. And that supplemental evidence, for instance, let's say if you're saying that if your child had to go to this country that now you're going to be removed to, and now they're going to have to start life. What if they're in special education classes? What if they have autism? What if you have shared custody with another parent, and that parent is a significant part of that child's life? And maybe you and that parent, they're not together. So now this child will be completely, potentially displaced from their parent. So that gives them that sustenance, right? Now you have the child being split apart. So you have to make sure that you're providing affidavits, you're going to psychologists, you're making sure that the things that you're asserting and alleging, you are showing on paper. You can't simply say, well, they should connect the dots. Nope. Connect the dots, answer the questions that could be asked before they're asked.
Now, how strictly is the 10-year continuous physical presence requirement applied? And what events can stop the clock?
Yes, so it is very strictly applied. So when they say 10 years continuous presence, show every year, okay? Show every aspect and iteration of whatever it is that you're deciding to show that this is what I'm showing as continuous presence. So if you're saying education, then that education needs to be clearly 10 years from year to year, report cards, evidence of enrollment to show that this has been a consecutive, continuous 10 years, okay? Now, one of the aspects with regards to not submitting that information, and it will, in fact, lead to denial. So it's important that when you're lining up that evidence, you make sure that you're showing absolutely everything. Things that will break that clock or stop the clock will be the NTA. And the NTA is the notice to appear. That is simply the document that comes, and it'll be a government form, an 860, 862, but it will be saying that you have been ordered to report to the immigration judge and the reason why. The minute that you get the NTA, that is when the clock stops, and now you're looking from then backwards to create that 10-year presence, okay? If there's any form of criminal offense, that criminal offense stops it, and then you have to look and check backwards for 10 years, okay? Yeah. And then again, that criminal offense can be at times a problem. So it just depends.
Now, for individuals who are not eligible for cancellation of removal, what alternative forms of relief should be considered?
Sure. So there are various forms of relief that are available to individuals. And how I like to think of it is, you are living your life, things are happening. And one of the aspects that's going on in your life may be immigration. Okay. Just a parallel to that is you're living life. And another aspect that could be happening in your life could be medical issues, right? So immigration realizes that there's various things that could be happening in your day-to-day life or may have happened in the past that if you're talking to that professional, they can say, wait, hold on, you may have an application for blah. Okay. So one of the things is clearly, if now you're telling me I have a notice to appear, I came in illegally, but my wife, I'm like, whoa, your wife. Okay. Tell me more about your wife. Because now, if your wife is a US citizen, now we have a potential path to citizenship. We're going to have to go through the process of you going out of the country and coming back in and doing consular processing. But now having this conversation and truly talking openly to your attorney could open up marriage base. Okay. Another aspect could be a U or a T visa. Okay. So it's like if you're dealing with any form of criminal activity that you know about or have been a victim of, and in having those conversations, if that comes up, you could potentially be have an ability to have citizenship through that event or those events. Okay. Another one is the Violence Against Women's Act, right? And it says women, but it is not. It is gender neutral. So if you're an individual and you are a part of a family that is a U.S. citizen or a lawful permanent resident, a mother, a father, a child, a spouse, and they have done anything to you that has led or rises to the level of abuse, that's emotional, financial, or physical, you can now self-petition. So these are all things that when you're talking to your attorney, if those are discovered, then that could be passed to citizenship.
All right. Thank you so much for those insights, Attorney Womack. Now, for everyone watching, this conversation about cancellation of removal is not meant to create false hope, but to provide clarity and understanding around a complex legal process. Immigration court proceedings can be overwhelming, and outcomes often depend on how well a case is prepared and presented. Having accurate information allows individuals and families to make informed decisions and better understand their options during removal proceedings. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We are also proud to share that ImmigrationQuestion.com is Triple B accredited and ISO certified. This is reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Womack, based on your experience, how does ImmigrationQuestion.com help immigrants and immigration attorneys such as yourself?
So I think this organization creates a wonderful gap, right? Or bridges a gap rather, right? Because you have immigration professionals, the attorneys who are out here working, right? So if I'm constantly working and I'm working on my cases, sometimes I don't have time to stop and have those conversations, those preliminary conversations, right? So what Immigration Question does is it allows webinars like this, right? That provides education for individuals to tap in, to check in, and to figure out what could I possibly have a claim for? What could potentially be my path to citizenship? What do I need to make sure that my immigration status is where it needs to be, right? So keeping your ears to the ground, this is what Immigration Question does. Then when you say, you know what, I pick up the phone, I need to talk to someone, you're talking to professionals who are substantively aware, as well as just simple, kind individuals who now will connect you to attorneys who can try to work to help you. So I think it's an excellent platform. And I've been here for almost a year now, and it's been great. I'm happy to be associated with Immigration Question.
Thank you for those thoughts, Attorney. We appreciate it. Now, before we move into our live Q&A, can we tackle this important question? What are some common misconceptions about cancellation of removal for non-permanent residents that you believe individuals should clarify to avoid any misunderstandings?
So one of the most common misconceptions, and I think sometimes it will even simply be with any potential path to citizenship. You hear one person having success or failure, and then you automatically impute that to your situation and say you're going to have success or failure, right? So I think I have to a lot of times debunk and distinguish between someone else's situation and the situation that you're presenting me with, because there's a difference. There's one element. And attorneys always, when you ask us a question, we always say, well, it depends. Okay. And a lot of people are annoyed by that, but it is factually necessary, because one factor, one change, one alteration can trigger an exception where you may not qualify, or where the ruling could potentially be different. So I think that's one of the biggest the misconceptions is, I have this, I have that, my friend did this, so now it's success for me or it's failure for me. And with this 42B, again, they believe, individuals that I've talked to, they're like, I have all these elements, it will work. I'm like, immigration is all discretionary. We have to make sure that information is provided in the correct way. It's organized, it's concise, it's answering questions that have not even been asked, and it is clear. So I think that's the biggest thing, is just the misconceptions and comparisons.
If you're just joining us, we've been speaking with immigration attorney Natalie Driver Womack on cancellation of removal for non-permanent residents, eligibility strategy, and real case scenarios. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. My story has gaps and I don't have the full records. How can I prove the 10 years of continuous presence?
Right. So I'm assuming that you're probably saying maybe like you may have like 2 or 3 years of this, 3 or 4 years of that. And I completely understand, because if you are here and you do not have status, there's certain things that you're just not going to trigger, you're not going to be a part of, because you don't want any red flags to connect you or to highlight you. Okay. So what we then work to do is we work to say, okay, tell me about your life. Where are some of the things some of the places that you have been, some of the things that you have done? And maybe without realization, you have created some form of presence and record that is there. So we could take maybe 2 to 3 years of school. We could take maybe another 3 to 4 years of maybe you filed taxes with an EIN number, right? And then maybe there's another period where you were in some form of organization, right? And we can show that you have presence there. So it can be a hodgepodge of information. So don't think that it has to be 10 years of continuous presence in a thing, right? We would just work to show, highlight, here's 2025, here's 2024, information on 2023. And it doesn't have to be the same type of information, but we're going to show that you have not left the country, you have been here for the full continuous 10 years.
All right. What circumstances may count as exceptional and extremely unusual hardship for me and my family?
I think that is an excellent question. So that is, you're hitting those exact words: exceptional, extremely, okay? And also I have to highlight the word discretionary, okay? So the judge is gonna look at a totality of the circumstances from the evidence that is presented. So they're gonna be looking at you holistically. So when it comes to this aspect, your exceptional and extreme unusual hardship, you're basically putting your whole life open and bare in front of the judge to see, right? So some of the extreme and unusual hardship will be, let's say if you have a family member who has a disease, that disease or that medical condition requires continuous monitoring, it requires continuous help. You're the person who's taking them to and from the doctor. Maybe your parents are elderly, and as a result of your parents being elderly, maybe they're suffering from dementia, things along those lines. That is an extreme and unusual hardship. It could be dealing with kids. Maybe your kid has issues that if you were to remove them to another country, maybe that country doesn't have the things that your child needs. Maybe if your child has special needs, that country that you're going to be removed to does not have the special needs that your child would require. So again, it would be having those conversations with a professional to say, hey, this is what my immigration status is. I've heard about the cancellation of removal. I'm in removal proceedings. Is this something that you think that I could apply for? And then that's when that conversation starts happening. Tell me about your life. What is going on? What do you think to be a hardship? So you start there. Tell the professional what you think is a hardship.
All right. With how strict immigration policies are now, had it become harder to win cancellation of removal cases? I think, has it become harder to win cancellation of removal cases?
So yes, everything has become harder. Okay, that is just the reality, and that's the place of where we are. Okay, but no matter what, if you find yourself in the situation of being in removal proceedings, you have to act, regardless of the fact of what is going on. Right. So we're on the side of immigration that you have to act. Okay. So being that you act, now the requirement is, let's make sure that you're aligning yourself with a professional who's willing to make sure that all questions are answered, your paperwork is sound and tight, you're making sure you're making all of your appearances, and you're doing everything that you are physically that you're physically able to do, right? And legally able to prove. So that's the thing. But it's harder. It's harder. I'm not going to lie. But it doesn't mean that it can't be done.
Yeah. Now, Attorney Womack, recent reports indicate that pregnant immigrants in detention have raised concerns about gaps in access to adequate medical care. These reports highlight broader discussions around detention conditions and the treatment of vulnerable individuals within the immigration system. When individuals hear about the issues affecting vulnerable populations in detention, such as pregnant immigrants, how should this inform their understanding of the immigration system overall?
Right. So again, we're just in a different climate now. So things that you would think would be normal or just second nature, it's not, right? So you do have individuals who are young girls who may have, come into the country illegally. They may have been sexually assaulted, and as a result, they are now pregnant. Okay. And they need medical attention, they need medical care. So if you are an individual who is listening to them on the other side of the phone, you're trying to be their advocate, I think there's certain things that you can do. And, I have clients who are in detention centers and in the detention facilities. And, even before we start the conversation, I'm like, no, how are you? Like, how are you doing? Right? Like, I need to know physically what are your medical issues? How are they physically treating you? One client told me, he said, the food is horrible. I'm like, that I can't do anything about, right? Like, I can't do anything about the food, but if they're not feeding you, like, I'm ready to step in. So one aspect of being able to step in for a loved one is making sure that you're writing down the things that are happening, right? So you make sure that you write the date down, the incident that happens. And if you're lucky, take down the officer's name where the encounter happened, okay, or who the encounter happened with, okay. Now, mind you, I know sometimes they're not wearing their name tags. You know what I mean? There's the intent to not show exactly who they are. And for some instances, I understand why, because they're worried about retaliation. But in some instances, I think it's done so that these things can be done and no one reports, right? But you don't let that stop you if there is someone that is a loved one that you need to help. So take down all facts that you can. Tell your loved one to also write down what they can. A lot of my clients, they'll have their notice to appear. So tell them to turn that notice to appear over and start writing down dates, times, what's going on, because this is what is considered legally as a recorded recollection, right? Normally you can't say, Bob, the security officer, hit me, right? Because you would say that this is hearsay. You cannot admit this into evidence. But an exception to the hearsay rule is recorded recollection, okay? And a recorded recollection is what you've written down, date and time, and you can say, well, this is an exception to the hearsay rule. This is something that they have experienced, and I would like an entered for the truth of the matter asserted, Okay, so now you have that information in the event that you need it. Another aspect is to know that there are entities that you can tap if there are problems. Okay, so for anyone that's that's listening, take down this. An individual in the detention facility can dial 9233 pound. Okay, the number is 9233 pound. They can file a report. It's confidential and is set to be anonymous, but they can state what issues that they are having. Okay, now if it's a client that I have and they're dealing with issues, I tell them to do this, but I also tell their family members to file a report, right? And you can file a report. There's various organizations that you can tap. There's the Office of the Immigration Detention Ombudsman. Okay, so again, that's the Office of Immigration Detention Ombudsman. All right, you can also tap the DHS, Office of Inspector General. And once you go onto these websites, they will allow you to file a complaint. And again, don't just say they are hurting my loved one. It's not going to work. Okay. You're dealing with courts, you're dealing with the government, so you have to be specific as you can. My family member is, say their name, their A number, because the A number, which is their alien registration number, that is the number that connects them. For the US, it's Social Security number. For individuals in the US who do not have status and looking to get status, they will have an alien registration number. It will immediately connect them, tell them what facility they're in, the harm that has resulted, the date and time that it alleged to happen. Okay. And then what you're doing is you're lining up various areas of evidence. And then as your attorney, I come through and then I'm sending in potentially a motion to have this matter looked into. But you don't have to just sit on the sidelines and say there's nothing that we can do. You have to now be armed with what power that you have and use it the best way that you can, and work with your attorney to do, to make a move for your loved one if you can.
Yeah. Thank you so much, attorney, for those valuable insights. Remember that number, 9322 pound.
Yeah.
Thank you to everyone who joined us for this special edition webinar, and thank you, Attorney Womack, for sharing your knowledge and practical guidance with us today.
Absolutely. Thank you for having me.
You can always visit immigrationquestion.com to ask immigration-related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of this important discussion, the replay will be available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Saturday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye-bye.